Good afternoon, everyone. I'm Matthew Sharp, partner in the dispute resolution team. Delighted to be moderating this next panel of the day, which is on the group actions landscape. Start off by introducing the panel. Ronit, come to you first, if that's okay.
Hi, yes, I'm Ronit Kreisberger. Is that mic on? Can
yes.
You hear me? Yep. I'm a competition silk at Monckton Chambers and have had the joy of a number of collective actions going through the CAT at the moment.
Fantastic. David?
David Greene. I'm partner at Edwin Co. I'm also co-president of CALLA, Collective Redress Lawyers Association, and I've been doing group litigation since the 1980s. Well, many of you were in practice.
I'm Elly. I've been in funding for 8 years. I'm a partner at Hereford Litigation. We're a global funder based in London, financing, unsurprisingly, litigation finance and legal assets opportunities.
I'm Roger Milburn. I'm an investment manager at LCM here in London. Recently returned to London from setting up our Singapore operations in 2018 when I joined the funding industry.
Ronit, if I can come to you first, just to set the scene a little for us and tell us about some of the recent cases, CAT decisions, what's going on in the group litigation landscape.
Yes, thanks, Matt. I'd be happy to. So I've been asked to say a few words about what lessons we could learn from recent CAT judgments. Now, it's probably fair to say that there's been just a little dissatisfaction with the collective regime in the CAT from all sides, funders, claimants and defendants. And we now have the government consultation raising questions about its future. And I'll certainly be listening with interest to what Roger and Elly have to say about that. But my theme today is that I'd really like to suggest that reports of the demise of the regime are greatly exaggerated, to quote Mark Twain. And so I'm going to call this part of our panel session Reasons to be Cheerful. To be fair, it's not a very long presentation, but I do like a challenge. So if there's time, I'm going to focus on two alliterative topics, damages and defendants' data. So damages first. Now, the question of how CAT should go about measuring damages in competitional cases and collective actions is obviously pivotal to the working of the regime to protect consumer welfare, its objective, by returning infringers' ill-gotten gains to the class, but also ensuring that there is an appropriate level of reward for funders, given the extent of the risks that you take and the costs of this type of litigation. Now, the traditional approach, as you no doubt know, to measuring damages is compensatory. You look at, say, the prices paid by consumers in the actual world, tainted by the infringement, whether it's buying from a price-fixing cartel or a dominant firm that's excessively pricing, and you then construct a counterfactual from which the abuse or the cartel is removed and the delta is the available damages. But there are many situations now in the modern digital world where a straightforward comparison of that sort between the actual tainted price and a competitive price simply doesn't work. And it won't capture the full extent of compensation that's necessary. So it will underestimate true damages. And so what I wanted to flag for you all is that there are signs that the law, as applied in the CAT, is beginning to catch up with that problem. And this is good news. This is good news for funders. It's also good news for the consumer. There are, as you will no doubt know, 3 measures of damages available in principle in general. Compensatory damages, and what I'd like to focus on are something called compensatory user damages. There is a judgment hot off the press in the Meta claim just last week on that topic, so I'll spend some time on that. Then in principle, there are restitutionary damages, a more remote possibility, but nonetheless a possibility. And there are also exemplary or punitive damages. So the Meta case first. Dr. Lovedall-Gormson is alleging that Meta deals unfairly with Facebook users by taking their data for nothing and then monetising it for exponential amounts of advertising revenue. And the claim originally alleged that in a competitive counterfactual, Meta would in fact pay for that data, and that was the original measure of damages. Meta refutes that on the basis that it says it would never pay for the data, so users, Facebook users, the class, have suffered no loss. Dr. Gormson has now applied to amend her case to allege that users should be compensated nonetheless for Meta's interference with their data. And that's where user damages come in. They're based on a Supreme Court judgment called One Step from 2018, a few years ago. That case involved damages for breach of a restrictive covenant. But the measure of damages for interference in a user's data is what a hypothetical reasonable and willing buyer would pay for the data. So it gets around the problem that Meta says, well, look, we'd never pay for it. So, as I say, last week, the CAT, in a very short, pithy judgment, flatly rejected Meta's attempt to strike out the claim for user damages. So that claim now goes to trial. It's a very significant ruling for three reasons. The first is it has real ramifications for big tech cases involving data use, where money doesn't change hands, which, as you know, is the model for most social media platforms. So it's a recognition of the value of that data, notwithstanding no clear monetary value to the user. So that's the first point. Now, the second point is, although the CAT was careful to refer to this head of damage as compensatory, it says in a number of points in the judgment, compensatory user damages, actually, the focus is not on the harm suffered by the class, by the consumer. The focus is really on the value of the data to the defendant firm that monetizes the data. You have the hypothetical, the notion of the hypothetical buyer. So not focusing on individual harm, user harm, but on the value to the buyer, which brings me to my third point. This is edging closer to a restitutionary form of damage. You're focusing on the objective value of the data. And I don't think the significance of this should be underestimated or understated, and it may flag quite an important shift. We may see more movement, and what it certainly does is it sidesteps a lot of the problems associated with compensatory damages. So that's user damages. Just a brief word, as I said, it edges closer to restitution. Restitution focuses on the wrongdoer's ill-gotten gains to measure the harm. And it achieves the disgorgement of unlawfully made profits. Now, the received wisdom is that restitutionary damage is not an available head of damage for competition law infringements. That's following quite an old Court of Appeal judgment called Devonish. Aside from the care that the CAT took in Meta to call this a compensatory head, Professor Mulheron, who some of you may know, she's a distinguished academic, but she's also a panel member of the CAT. She's an ordinary member. She wrote an influential article suggesting that at least for collective actions, it's time to revisit the Devonish bar on restitutionary claims. And what she stresses in that article is that There is the difficulty of quantifying compensatory damages, and we've seen that in some of these cases, and interchange, Merrick's comes to mind. It's much more tractable if what the CAT needs to do is measure the defendant's gain, which is what we're seeing in Meta, arguably. And the concern with restitutionary damages, or one of the concerns, was that it results in windfall gains because it overstates harm suffered by focusing on the ill-gotten gain. But Professor Mulheron makes the point that the collective regime is well placed to deal with the distribution problem to avoid windfalls. So again, I think this is potentially good news for funders. In that article, she's really inviting a class representative to formulate a claim on this basis. So it'll be interesting to see if someone's bold enough to take on the challenge. Just a final word on exemplary damages. Exemplary damages are punitive damages. They were awarded in a competition claim back in 2012. They were then excluded by statute. So punitive damages can be higher than compensatory. Post-Brexit, these damages are available again for competition infringements, but not in collective claims. But if one's funding an individual claim, exemplary damages, particularly for the really bad cases, is back in action. So it's another measure of compensation that's worth thinking about when you're looking at whether to pursue a claim. I'm happy to stop there, Matt, and come back to data if there's time.
Yeah, that'd be great. Elly, I think coming to you next. Reasons to be cheerful about the future of group actions in the CAT, or are you in the demise camp?
Well, I think it's always really important when we're speaking about group actions, and I labour this point quite a lot when we're talking to clients and law firms. Group actions in the UK or England and Wales is, we're not restricted to the CAT. And I know it's the buzzword, and we've all got, a lot of money in these very, very significant cases, and we all want it to come good and to see the returns and the outcomes for claimants that we're all expecting and have been pleaded in the filings. But let's extend group actions beyond the CAT just momentarily. We could argue, a thoroughly working regime, which is the GLA regime, under which the omissions cases are obviously fast proceeding. I think they start trial, all being well, with lead counsel on the claimant side in a matter of, I think it's like a week. And we'll see what comes out of that. We've obviously historically there have been some very successful outcomes under the GLA regime, the HIP manufacturing, tort litigation. David, help me out. What else have we had? Big GLO cases.
Big GLO cases with all the NOxes.
Emissions.
Emissions. There aren't that many GLOs. Actually, I had a quick look this morning about GLOs because I've certainly done work on GLOs, and there's a government register for GLOs. The last one was registered in 24, so you don't see them that often. And if I'll go on about GLOs to this extent, is that so I've been doing group litigation and collective actions for many, many years, really starting in mass torts, and the tendency has been against GLOs rather than bringing a sort of mass claim with thousands of people on a claim form, because the management you're buying into the management of the GLO. I think from a funder's point of view, funders get a bit concerned about free riding for GLOs. So the tendency has been against GLOs, and I think that is reflected on the register, that there aren't that many being registered. And if we look really, the main ones on the register at the moment are the NOxes litigation. I should say that my co-president, Martin Day, loves GLOs. He thinks they're really effective.
Funny that.
But yes, indeed, on NOxes. But they haven't been that popular, actually. And from our point of view is we might put 1,000 people. I think the largest one I did was a rail track litigation many, many years ago. We put 50,000 people on one claim form and do it that way.
We've also obviously got we're awaiting the judgment in the BHP Vale Fundal Dam claim, which has been brought by Pogus Goodhead on behalf of many thousands of Brazilian claimants, individual claimants. And I think we wait with bated breath to see where that takes us next. That proceeded, other than the jurisdictional spat, fairly quickly through the courts to its liability trial. It was a liability, not liability and quantum. They've been separated. And then, I think we could also argue the domain of securities litigation is group litigation. They're large groups of institutional investors, not necessarily retail investors in this jurisdiction. And those claims, we haven't seen one proceed through full trial for a very long time, but that's because they've settled. There is still some law to be worked out, particularly in the domain of reliance, and I think there are some appeals being heard in Barclays and what was the other one? Standard Chartered in a matter of months. But I think I'm very keen to impress upon everyone here that group litigation is not restricted to class actions in the CAT on an opt-out basis, and we're going to talk later about opt-ins. But they're great, they're flourishing, largely. Perhaps there are fewer GLO claims than we'd like. Everybody please put more GLO claims together and call Hereford. So there's that. And then, of course, from a funding perspective, and I'll hand over to Roger, we've heard lots, I think, this morning about the general sentiment that we'd like to see some kind of slightly more positive movement and more efficiency in the opt-out domain of group litigation. I think the buzzword that I would want everyone to take away from this is reasonable expectations of a funder and kind of building on merits. And to build on what Ronit said, it's all very well having a fantastic array of potentially increasing damages options to plead for your classes. But if funders can't take a portion of those damages in consideration for the very significant sums that we are putting up to finance these claims and take the number in merits, perhaps not the perfect bellwether example, but £45 million, there has to be reasonable expectation that a contract, which is your litigation funding agreement, is not going to be pulled apart at the final furlong by the tribunal. And I think that is the key issue that requires resolution, and extremely swiftly, because it is affecting the amount of capital being deployed into these cases, and I think that's not a secret.
Elly, David, can I just pick up on one point you just made around GLOs? Do you see appetite for GLOs increasing or not changing as a result of kind of issues in the CAT and otherwise?
No, I don't think they're affected. I mean, I'm naturally optimistic, so I'm very optimistic about the market. I mean, I think the problem we have at the moment is some growing pains. I don't know how long this conference has been going. 4 years, I think this might be the fourth year this conference has been going, and it wasn't this full then. It was a lot emptier, and it just shows the interest in the market and what's happened over the past few years. And we're just seeing some growing pains, particularly I think in the dynamic between the courts and funding claimants, bringing claimants together. All of this is some growing pains, which we'll get over. As far as GLOs concerned, I think the major thing that was going to push for GLOs was the Abbott decision, but that's been reversed with Morris. You can put as many people as you like on a claim form, as long as they've got the same interests. So I think that's a way forward. I think GLOs, still from a solicitor's point of view, are not hugely attractive because you're handing over the management of the case very, very much. So, and indeed, of course, you're bringing on a carriage battle immediately as to who's going to be lead solicitor in the process. Look, there are just lots of ways that we can provide access to justice for our clients. And when someone comes to us and they've got a common problem with others, we look at the shelf and we pull off the method that we think is the best way that they can get access to justice. And GLOs is a possibility of one of those.
I mean, it goes without saying, just to build on one of the problems with GLOs, other than the relative lack of large cases that you can pin a GLA to, and Knox is enormous, and it's obviously the kind of the key example that is very, very live at the moment. But GLAs are very expensive. They require book builds, they require marketing, they require you to, any funder worth its salt is going to want to see a certain threshold of headline damages built across the claimant class, or claimant group, I should say, sorry, represented by the instructed solicitors. And there is risk inherent in that for a funder. You might, goes without saying that it's highly plausible that thresholds aren't reached, and there are also quite a lot of cowboys as we all know, in the space of claims management and the building of such books. So that's a big risk, and it's expensive. And you need some proof, and often the entities that promise the ability to build you a very sizable book can't demonstrate a track record. So you're taking significant risk in that domain. And I mean, I think this isn't the right forum to start talking about PCP and what might come from that, and I'm sure others have spoken about it today. But that is the risk with GLOs. It's also a problem with opt-in CAT litigation. You need a firm and or others involved, a law firm on the claimant side, and or others involved in the case, to be able to build you a requisitely large book of loss across corporates, let's say. And hat off to Genevieve Guerin at Stevenson Harwood for building, and that's a very recent example, the book of supermarket retailers in the salmon cartel case, which is an opt-in case brought in the CAT, and I believe it is funded. But they're tough, and it requires law firms to dig deep and to leverage off, if they are multi-practice, their finance and their corporate teams. And my view is we don't see enough firms doing that. And I think that from a funding perspective, currently, given the current state of the nation, it would be great to see more opt-in proposals, not necessarily just in 101 cartel claims, but in 102 abuse of dominance claims as well. Roger?
In particular, Roger, interested in your perspective, obviously having been working very recently in other jurisdictions as well, and kind of your thoughts on the CAT and where we're heading, and comparatively with other jurisdictions as well.
Yeah, well, when I left the UK, the CAT didn't exist. So I was away from 2012 until this year, and so I've come back and I've inherited some claims to manage within LCM, specifically CAT claims, and I've had a sort of look at the market with a sort of an outsider's view, if you like, because the jurisdictions in which I operated in Asia didn't have class action regimes. So this is all relatively new to me, and while we're on reasons to be cheerful, I can do those very quickly. I have a lot longer list of criticisms. I think the judgment in which it was said that subject to final sign-off by the CAT, funders can be paid ahead of the class and not have to wait for undistributed damages, that's good, that's great for us. Beyond that, what I've seen looking back over the last 10 years of the CAT is just sort of slow-moving traffic, if you like. Lots of procedural scraps. But the ray of light, I guess, for now, is it feels as though the tribunals within the CAT have started to send the message, or have received the message, that things need to be moved on more quickly now. And certainly in the cases that I'm involved in, we are noticing a push from the tribunals to get these things moving quicker. And I think all funders will welcome that.
And if we can do a bit of a quick fire round on this question, because it's a topic that's come up a lot today, but concentration risk and CAT in particular. I mean, Roger, maybe if I come back to you first on this from a funder's perspective, but thoughts on concentration risk in the CAT?
In terms of the concentration within individual funders, I think it clearly exists. There are a number of reasons why less money is going into the CAT regime at the moment. And that's, again, associated with time. Duration kills investments, and I think a lot of the market is waiting to see the output from the claims that they've invested over the last few years as funders. And I think, you only have to look at the figures to show that the number of claims being brought in the CAT, I think it's 3 this year, 7 maybe 11 last year and a few more in 2023, that number is going down. It's dwindling, and a large part of that must be due to funders' appetite, whether it's concentration risk or not.
Yeah, I mean, to be very direct, we're waiting to see a good settlement. Has there been one yet? I'd maybe put that to the floor. We could debate that. My view is no. And we need to see a good outcome for the class and for funders combined. I think there's a lot of hope. On the one hand, pushed onto the Kent decision, Kent and Apple, which is, I think, awaited. I'm always very conscious that we all operate in something of an echo chamber, and we're all telling one another that Kent's going to be the one that makes everything good. So I take that with a slight pinch of salt, but fingers crossed, and maybe will then be a way to the races. But I think that lack of conclusive evidence that this can generate the expected returns or close to of a funder when it enters into the LFA with the class rep it's what we need, and we hope we'll get there. And in the meantime, I think it is very tough to get one of these cases financed. I think if you've got a great case, there's no such thing as a slam dunk case, there's no such thing as a slam dunk opt-out case, then I think there is still some appetite. Maybe it's a follow-on claim, and it's pretty narrow, and you've got a very, a firm that knows what it's doing and a decently, very thoughtfully put together budget. I think the AT insurers, from what I know, I think are also, there's capacity and they want to write good risk. But I don't think there aren't 10 of those cases a day. I think that presents an opportunity, you could argue, if you are a funder with capital, to put 30 down into a single case. Hereford is one of those. There aren't many of us left. Yet, we want to see, it's a good position to be in. We want to see the very best risk. But I was told by one unnamed law firm a couple of weeks ago, when I turned down an opt-out case for very, very sensible reasons, that there was always going to be money in the US. So.
And you say, putting down 30 on a claim. That 30, certainly from what I've seen on the cases that we've had within LCM, may well turn into 40 or more, because largely, apart from a bit of experimentation we've seen from the CAT in one particular case on how disclosure was run, which was a bit of a failure, certainly very expensive. What I can see is that there is a menu of things for defendant law firms to complain about, which each one of those complaints will increase costs because they have to be dealt with, whether there's a CMC or not, or some other sort of form of hearing. All of this increased costs, and it feels to me that there is a lack of a sort of strong hand or a governing hand from the people making rules and the people running the claims, i.e. the CAT tribunals, which means that you may be looking at a claim where you're asked to put in 30, but you have to think about what that number realistically is, unless there is a crackdown on the costs that seem to be running away.
I mean, I think, because this is meant to be a panel about optimism in the group action space, I think.
It doesn't
say
say
that.
We'll go with that anyway. So
We're all optimistic. I would say, glass half full perspective. With that point comes, we've all been saying it for ages. I think we haven't really seen the development of the secondary market here. There's a lot of waffle about it. I genuinely do think that this juncture now may truly be the development of that market, and I think we are starting to see some kind of encroaching opportunities for top-ups from funders who are out, they're maxed out, building on the concentration risk point, and need 5, 10 to take something, to bring something home. And there's not very much money in the space currently that you put 2 and 2 together and work out that it's a buyer's market, so to speak, in terms of pricing there.
I'm personally not surprised that there are fewer cases. First of all, is that after the Act came into effect, is we as claimant lawyers, and I think all claimant lawyers, were looking at the opportunities, what this meant actually, and therefore, in a way, as we were looking at historic events from there, and if we look at the cases, they're often about historic events and continuing, but historic in a way, so that it's unsurprising that I think there are fewer of them coming up. I think concentration is also an issue. And of course, concentration in terms of funding, it's not just this jurisdiction, but you look across the whole of Europe. I can think the case we're involved in was trucks. Well, there are many actions in many jurisdictions, often funded. So I'm not surprised at any of that and I do think, as I say, I think there is reason to be optimistic because these are growing pains. We should expect these growing pains at this point. The CAT, for instance, is hugely inexperienced with respect to them in relation to running these cases. From the point you make is being disciplined, not allowing defence to ride roughshod over procedure and just pushing the costs up because that's what they do. That's their job, is push those costs up, make it more painful for claimants. So I'm just unsurprised about any of these developments over these past few years. And we'll get round them, just as you say, in relation to the Meta case, for instance.
Yeah.
That was rejected initially, if I remember that case.
That's
I think
right.
I watched it on
right.
live to see what was going to happen. That was rejected. Tribunal said, actually, go away and come back again. And they've come back and now got through that process. So it's all about development, and that's the CAT actually being quite expansive about the application of the law, trying new lines in relation to these cases, and I think that the CAT itself sees itself as providing that access to justice, and I think we'll see a picture, a much more steady picture in the coming years.
And I think also Elly's right to flag Kent. I mean, no one wants to rely on a single judgment. But the hope is, as Elly says, it could be a game changer in two respects in particular. One is a point that came up in Le Paterel and was, in my view, unsatisfactorily addressed by the CAT, which is what do you do in cases involving the defendant's costs, particularly these excessive pricing claims, as Kent is. What do you do when the defendant firm says, well, we don't allocate our costs in this way, so we can't give you very much? Who do you give the benefit of the doubt to? In Le Paterel, quite surprisingly, they gave the benefit of the doubt to BT. It will be interesting to see if a different approach is taken in Kent, what they say about what Apple's produce. So that's one area which will have ramifications for a lot of cases. And the other area is pass-on, which brings us back to damages, because it's a consumer class. Unlike coal, which is listed for a year from now, which is essentially the parallel claim against Google for App Store charges, in coal, there is a class of developers and a class of consumers. In Kent, there's only the class of consumers. So the damages award for the excessive pricing piece depends on establishing pass-on. So it'll be very interesting to see if we have a positive judgment that finds that the loss was passed on. It's called incidence in that case. It's horribly complicated. The economics of it are horribly complicated because Apple, by virtue of the fact that Apple just charges a straightforward percentage to the app developer of their revenues. But we're hoping for a positive judgment on pass-on in that case.
David, you mentioned growing pains. I'm going to, perhaps characterise this as one and ask you to comment on it. But it seems to me there's certainly a growing trend of judicial intervention on assessment of funders' returns and funding structures generally. Do you agree that's a fair assessment? There's a growing pain, and do you see it? How do you see it as a positive or negative?
I think it is. I think it is a growing pain. Actually, it's a really concerning growing pain. Actually, because if for a funder, as far as I see it, and I'm not a funder, I'm just a lawyer working on it, the problem lies is you're adding additional risk at the end of the case by saying to the judges what is a reasonable return for the funder. And with all respect to the judiciary, I'm not sure they're the best people to give a judgment on that, because there are so many factors that are built into the modelling for funders. Competition for other investments, all of those issues, the assessment of risk at the beginning of the case, not at the end of the case. And I do think that there's quite a lot of education, if I may put it that way, for the judiciary. And I think to some extent they accept it, that they really need to understand the funding industry in order to opine at the end of a case as to what the return's going to be for the funder. And if there's any concerns I have about growing pains, that's one of them, which is this judges deciding things at the end. Because I can see if I was an investor, that would give me some concern.
And do you think it's the principle of it? So there's 2 points to this, I think. There's one around the judiciary and their understanding of the economics of funding, and then putting their own views on it. And there's also a timing point there of it being at the end of the case rather than at the start of the case. And interesting in all the panel's views on this, but David, I can briefly come back to you on that.
Yes, well, I mean, so the requirement of the representative, we might talk about the representative in a moment, but the requirement of the representative is they have to take a view on behalf of the class that they represent. And I think what we're increasingly seeing is the requirements on the representative to be robust, to be independent, to negotiate strongly in relation to funding and with the lawyers, and we're seeing that. So that's fine. Then at the beginning of the case, they enter into an agreement with the funder, appropriately advised about the funding, and they come to an agreement, and that's the funder's agreement, and everyone starts the litigation on that basis. If you're now adding to that, actually, that doesn't matter, because at the end of the case, there'll be a different decision with someone else making a decision. I think that's a real problem, and I think that just needs sorting out. And I think from Caller's point of view is we need to speak to the judges and say, look, how can we sort that out to ensure that this process works? Because I think we're all agreed is if you haven't got funding, you haven't got CPOs. And if you want to provide access to justice through CPOs, which was very much the policy for CPOs, then you must have funding, and you can't kill that off.
I think there's no denial, though, that obviously there will be cases in which there are exceptional circumstances and it will require intervention in the interest of the governance of the class, which is the tribunal's role. Debatably, something akin to merit, so there are obviously issues with that, potentially with that judgment. But I couldn't agree more with David. We need certainty far earlier, I would say even before certification, but in and around certification would seem appropriate. I mean, take the Canadian model. It's a funder's got no money out the door before there is confirmation by the court that the funding returns proposed in the waterfall and the funding agreement are appropriate and are fixed.
Yeah. I mean, I'd just add is, I think enormous, be of huge benefit if we could just reverse PACAR and get that percentage back. I think that'd be really helpful to the whole process.
Probably the last topic we'll have time for, but the Department for Business and Trade have launched a call for evidence in relation to opt-out collective actions. Interested to hear your views on where you see that going. I mean, from my perspective, it looks like the government, on the one hand, is struggling with this very important tool in terms of consumer protection versus business certainty and protecting business and the economy. Do you think that's, Ronit, come to you first, do you think that's fair in terms of a characterisation of the struggle, and where do you see the review going?
I mean, I think it's probably a fool's game to speculate as to where it will go on the record. I think the concern is that the worry is that it's politically motivated, and there is some irony if it's right that it's really the concerns of big tech arguing that this is the reason that growth is being inhibited in this jurisdiction, when you have treble damages available in the US and it's not inhibiting big tech. And it really goes back to basic Room 101 economic principles, you know, that you need a competition regime with bite to ensure a fair economy, to ensure growth. Yeah. So it feels that it's the wrong target. It's unfortunate that we don't have better data at this stage for this consultation. It's just too early. But it is worrying that the government is even asking the questions at this stage rather than allowing the regime to bed in.
Well, I think it's telling it's coming out of the Department of Business and Trade rather
Yeah.
than the MOJ. We've just had the CJC report, and it does look as though there's quite a lot of politics sitting in actually in the wording. With all respect to the drafters of the review, it's quite difficult to understand some of the questions in it in terms of procedure. I think the other thing, and I think most people agree, is for us lawyers, it's far too early. What have we seen? We've seen one judgment coming out at the moment, and as I say, there are growing pains, and there are problems to be addressed. Distribution, I think, is one problem to be addressed in this process. There are problems, but from a lawyer's point of view, it's far too early really to be looking at this and seeing how it's working. We're seeing the common law work in the normal way it does, establishing precedents as we go along.
And just to add one point that picks up on a point that Elly made about, you know, the criteria for choosing cases. It was mooted at the outset before the regime was brought in that it could be confined to follow-on claims, and that I think that is one possible outcome of where we're headed, given the perceived breadth of the types of claims that have been brought.
Which would require the CMA to really hire some more people and pull its socks up.
Yeah. All I'd ask is for everyone is to answer the review. It raises quite a lot of questions, but to address those questions and answer a review, I think it's due by next Wednesday, 14th, is that Wednesday or Tuesday? Anyway, it's due very shortly, so a bit of work over the weekend in order to answer the questions.
Roger, from your perspective, any views on the call for evidence?
I don't think I've got anything that I can usefully add to what's been said.
Yeah. Elly, anything more on that?
I think it is vital, and obviously there's a lot of understandable focus on it presently. I think it's also important to remember that it is also 10 years into the statute's introduction, and that is, you know, this process, a review is very commonplace. So just taking some of the heat out of it, essentially.
That leaves us with some time for questions. Are there any questions? Yeah.
Sorry, do you mean in general?
In general, the landscape today has been 5 odd years of procedural wrangling. Are all of those points well made and that we've now concluded the procedural wrangling, or do you perceive more trouble ahead procedurally?
I think we've obviously got a new regime in the CAT with a new president, and I think she, I'm speculating, but I think she is going to want to really get a grip on these procedural skirmishes. I think she's going to want to, I think her KPIs are going to be duration to trial, which I hope will be music to funders' ears, as Roger said. That's a key metric. I think she's going to be very focused on that. She's a president who is very serious about having shorter documents, We had a CAT chair and a judge in the High Court saying just this week they are unimpressed by the volume of expert evidence. I think they want to pare this back. So I think, obviously, at the start of a regime, you get a lot of left field applications. I think and I hope there's going to be lower tolerance of it. It generally comes from the defendant side because claimants just want to get to trial. So I'm hoping we'll see fewer of them. I think many weren't well made, and I hope for a more efficient and effective regime going forward.
Yeah, and it does need, it is, as we've been talking about, it does need that judicial intervention and strength to ensure that proceedings are effectively and efficiently run and proportionate to get to trial for consumers.
I've got time for one more question, if there's anyone else. No? Very good. Can you join me in thanking the panel?
Yeah.